Hey guys, Happy New Year's. I hope this video finds you well. I hope this new year brings you plenty of prosperity and success. Please like, comment, and subscribe. That will help get this video past the algorithm, get it to the places that it needs to go, and help get this channel pushed past the algorithm. It will increase the subscribers, increase the traffic, and help our channel overall. The purpose of this video is for information purposes only. It is not for entertainment. It is not for the promotion of criminal organizations or violent extremists. It is simply to inform the public and fulfill a request that was made to me if I could do a video on jury nullification and the process of jury nullification in general. And that's what I intend to do. So with that being said, let's start the video. Recent events in New York City, 28 days ago from the publishing of this video, started the public's interest in what is jury nullification and what the process entails. As we know, in New York City on December 9th, it was announced that a person of interest in the December 4th events was apprehended in an Altoona, Pennsylvania McDonald's. And the following day, on December 10th, the person of interest said, "It is completely out of touch and it is an insult to the intelligence of the American people and their lived experience," alluding to being scapegoated and railroaded. I'll leave that up to you, whether or not that is true, whether you support or oppose the person of interest, innocence or guilt. My purpose here is to explain the process of jury nullification. So as we know, on December 10th, 2024, there was a court proceeding in Altoona, Pennsylvania, where the aforementioned quotes were made. Then on December 19th, 2024, the person of interest waived extradition and was sent from the Commonwealth of Pennsylvania to the state of New York in a highly publicized perp walk that included the mayor of New York City, Eric Adams, making a statement that could come back to haunt this case and the prosecution's efforts against the person of interest. Then, on December 23rd, 2024, the eve of Christmas Eve, the person of interest was in New York court, where he pleaded not guilty. And his lawyer mentioned that the highly publicized perp walk and the statements made by the mayor of New York City, Eric Adams, the indicted mayor of New York City, Eric Adams, may violate his rights to a constitutional fair trial by interfering with due process. His attorney, Karen Agnifilo, the person of interest attorney, Karen Agnifilo, also mentioned that in addition to concerns of not getting sufficient due process, she also raised the concern that her client may not get a fair trial due to double jeopardy concerns. As we know, many of the charges against the person of interest in the Pennsylvania case, the New York case, and the United States case tend to overlap with similar charges that are congruent in nature. So, now it's time to explain jury nullification, now that we have the context and the background of what we are discussing today. Does a jury have the power to find a defendant not guilty no matter how strong the evidence of guilt? Yes, jurors, not prosecutors, judges, or police officers, have the ultimate power to decide whether a defendant is guilty. As the conscience of the community, jurors can acquit a defendant even if they think the defendant really committed the charged crime. When jurors nullify a law by acquitting a defendant who has obviously broken it, judges and prosecutors can do nothing about it. A jury's not guilty verdict is final. Judges and nullification. Judges have the same power to nullify a law with a not guilty verdict. However, defendants who hope for a nullification outcome normally choose jury trials in the belief that jurors will be more sympathetic and feel less bound by the law. Can the defense argue nullification to the jury as a defense? No, the defense can't explicitly ask jurors to nullify the law. For example, a judge would quickly silence a defendant who said, "Jurors, I was only trying to protect my community against a poisonous waste dump. You should find me not guilty even if you think I did break the law." In fact, judges don't instruct jurors about their nullification power. Jurors who might consider a nullification verdict have to realize on their own that they have the power to nullify the law, or the public may inform them through information campaigns. Evidence that may lead to nullification. While defendants can't offer a nullification defense, they sometimes present a case in a way that leads jurors to consider nullification on their own. Cases that result in nullification often have these characteristics. The defendant acted out of strong moral conviction shared by jurors. For example, a defendant acted out of a desire to close a toxic waste dump, and jurors believed the goal to be legitimate. Evidence portrays the defendant in a sympathetic light. For example, jurors may sympathize with a defendant who broke the law trying to close a toxic waste dump only after making a number of legal efforts. Note, any sympathy evidence must be relevant to a valid defense. Judges don't admit evidence simply because it may arouse sympathy for a defendant. Evidence arouses jurors' hostility to the government. For example, jurors may be hostile to police officers who were too aggressive when arresting a person engaged in a peaceful but illegal protest. The defendant isn't charged with a crime or violence. What are the most common situations in which a jury might nullify a law? Jurors might consider a nullification if the jurors believe a law to be politically unjust. For example, during the Vietnam War protests in the 1970s, some jurors refused to convict war protesters who were charged with criminal trespass because they thought that a law banning nonviolent protests was unjust. In more recent times, jury nullification has occurred when defendants who nonviolently protest nuclear testing or toxic waste dumps are charged with crimes. The jurors believe a valid law is being unjustly applied. For example, in the film A Time to Kill, jurors acquitted a black father accused of murder after the father killed the two men who brutally raped his daughter. The jurors didn't consider the murder law itself unjust. Instead, the jurors thought it wasn't fair to apply the law to the father's conduct. Should a defendant turn down a good plea bargain and hope for jury nullification? No, defendants who rely on jury nullification are usually disappointed. Jurors almost always limit their deliberations to whether a defendant committed the charged crimes, political overtones, and feelings of sympathy or hostility notwithstanding. Jurors rarely acquit a defendant they think is guilty as charged. So there you have it. That explains the jury nullification process. Let me know in the comment section, what are your thoughts on jury nullification? Do you think jury nullification may be used by the jury in the Pennsylvania, New York, and United States trial against a person of interest in the events that have currently unfolded in New York City? In the cases Mangione versus New York, Mangione versus Pennsylvania, United States versus Mangione. Again, the purpose of this video was to inform the public upon a request that was made to me about the jury nullification process and how that process will likely unfold in any case, not just the cases mentioned. So with that being said, once again, please feel free to like, comment, and subscribe. It will help push our videos past the algorithm and get it exposed to more people. It will help with the traffic. It will help with the subscriber count. And it will help make this channel very successful in the future. So with that being said, I thank you for taking the time to listen. I hope you have a great new year. This explains the jury nullification process well. With that being said, that concludes our video. Take care.